All right. Hello, everyone. My name is Selena Cumming. I'm the Communications Director for the ACLU of Ohio. Thank you for joining today's press briefing on the partisan gerrymandering litigation filed today by the American Civil Liberties Union, the ACLU of Ohio, and Covington Burling on behalf of the A. Randolph Institute, the League of Women Voters of Ohio, and Ohio voters. Before we begin, we have some housekeeping notes. We are streaming live on Facebook right now. To start, all attendees have been muted to limit background noise as much as possible. And when it is time for Q&A, all attendees will be unmuted. There will be opportunities at the end to ask questions. And at that time, attendees will be unmuted. If you have a question, please state your name and your news outlet and either ask your question aloud or type it in the chat. If your question is not answered, please email either myself or Inga at National ACLU. We'll drop our emails in the chat. Like I said, this briefing is being recorded. We've enabled closed captioning. If there are technical difficulties on closed captioning, please alert us and we will send you a written transcript following the event. And at the conclusion of the briefing, we will send out a link to the full event and clips for coverage usage. And we don't anticipate any technical difficulties during today's briefing, but if there are any challenges, our speakers may temporarily go off camera to try to keep the audio uninterrupted. Thank you again so much for coming. It is my pleasure to introduce Freda Levinson, the legal director for the ACLU of Ohio. Freda, please kick us off.
Thank you, Selena. Good afternoon. An hour ago, the ACLU of Ohio, the National ACLU Voting Rights Project, and the law firm of Covington and Burling filed a lawsuit in the Ohio Supreme Court challenging the state legislative maps that were enacted last week by the Ohio Redistricting Commission. Our plaintiffs are the League of Women Voters of Ohio, the Ohio chapter of the A. Philip Randolph Institute, and 6 individual voters. The map, enacted along party lines with the 5 Republican members voting yes and the 2 Democrats voting no, is an extreme partisan gerrymander. In this state, where over the past decade, Republicans have received between 46.2 and 59.7% of the statewide vote, the Republican commissioners awarded their party 67% of the House seats and 69% of the Senate seats. This is a blatant violation of the Ohio Constitution, which in its new Article 11 forbids partisan gerrymandering. The article also specifically requires that the number of seats held by a party in our General Assembly must correspond closely to the voters' statewide preferences over the last 10 years. The Republican commissioners have admitted that over the last 10 years, they've received only 55% of the statewide votes, but the map they drew for themselves provides them with a locked-in supermajority. The enacted map sets aside the voters' preferences in favor of the majority commissioners' party preferences. Ohio has a sordid history of partisan gerrymandering, but the voters of this state do not want their districts gerrymandered. In 2015, by an overwhelming majority of over 71%, the citizens of this state amended the state constitution to forbid exactly this. The map drawing that just took place last week was the first test run under the new constitutional amendment. And what took place was an affront to that amendment. Even the Republican commission members seem to realize this. Governor DeWine candidly stated, even as he voted yes, that he was sure the commission could have reached an outcome that was, quote, much more clearly constitutional. Commissioner Secretary of State LaRose agreed that the map has many shortcomings and expressed fear that we're going to be back in this room very soon. Commissioner Auditor Faber also acknowledged that the map was not that good. We agree, the map could have been more constitutional. It could have been entirely constitutional. Yes, it is not that good. We are asking the Supreme Court of this state to order the commission draw a new map, a new constitutionally compliant map. It's now my pleasure to introduce my colleague, Elora Thomas, who is the Senior Staff Attorney at the Voting Rights Project.
Thanks, Freda. As Freda said, we filed suit in Ohio because it's an extreme partisan gerrymander and a blatant abuse of the people's trust and power. Ohio may be the canary in the coal mine from what we can expect from a partisan-dominated map drawing process this cycle. But the ACLU plans to be there to hold politicians accountable and make sure maps are fair. As the first state in the nation to pass statewide maps, Ohio had a promising opportunity to show the country what fairly apportioned electoral district boundaries look like. Instead, Ohio presented a map that was grossly gerrymandered and far from fair. And we know, not only from Ohio, but from gerrymandered legislatures all over the country, that politicians from gerrymandered districts are extreme and polarized, and more so than politicians from fair and competitive maps, resulting in policies and laws that do not reflect the will of voters. For example, despite widespread support for abortion access, free and fair elections, and gun control, the gerrymandered Ohio legislature has consistently acted contrary to the will of the voters. Many states follow a similar pattern, but Ohio is one of the most extreme. We will continue to fight to make sure voters choose their politicians and not the other way around. Now you will hear from one of our wonderful clients, Jen Miller.
Hi there. Thank you, everyone. It's a profound honor to be here today on behalf of my organization and the voters of Ohio, along with such an esteemed team of lawyers, experts, and plaintiffs. I'm actually here in Marion at the Harding Presidential Home, and it's too cold to sit outside of the press building that was built in 1920 to cover Harding's campaign. But I feel as though I'm here among, it's cool to do a press conference at the home of a pressman. Partisan gerrymandering is an insidious form of voter discrimination that harms every Ohioan, regardless to where they live or how they vote. And that's why the League of Women Voters of Ohio has been fighting against partisan gerrymandering for decades, both against maps that have been rigged to favor Democrats and Republicans. The Ohio Redistricting Commission ignored the people's wishes and disrespected the Ohio Constitution by failing to implement the letter and spirit of the 2015 reforms that passed by almost 72% of the vote. Instead, they ran a chaotic, rushed process, conducted negotiations behind closed doors, and adopted a map along party lines that is an extreme gerrymander. We are here today to ask the Ohio Supreme Court to stand up on behalf of Ohio voters and to declare the State House and State Senate maps unconstitutional. And we are also here to call on the map makers of the congressional map to have a better process and to ensure that the resulting maps are truly serving the people rather than the selfish and short-sighted interests of political parties and candidates. And with that, it's my honor to introduce a League of Women Voters of Ohio member, a dear friend, and the president of the Ohio A. Randolph Institute, Andre Washington.
Thank you to my friend Jen Miller, to the ACLU, and to my A. Randolph Institute members. I am the proud state president of the historic A. Randolph Institute. And today, sisters and brothers, I'm here to say that it is very disappointing that Ohio Redistricting Commission maps do not reflect Ohio's diverse makeup. In 1968, Dr. King gave a speech 4 days before he was assassinated. And he said, the time is always right to do what is right. And we have been asking the Redistricting Commission to do what is right, to do what the voters of Ohio told you they wanted you to do: fair maps, fair districts. Let us vote for our representatives, not our representatives voting us in. These gerrymandered maps will negatively impact minority voters, and it will maintain the status quo of voter suppression, and it will disenfranchise communities of color. So we're here today, the A. Randolph Institute, the League of Women Voters, ACLU, to ask the Supreme Court and to say to the Ohio Redistricting Commission, It is always the right time to do what is right and to do what the voters of Ohio ask you to do. Fair districts, fair maps. Thank you.
Thank you so much, Freda, Elora, Jen, and Andre. We will now open it up to questions. So please, if you are a member of the press, feel free to write your question in the chat or unmute yourself and ask your question aloud, and please state your name and news affiliation. Okay, so Andrew, oh, there you go. Go ahead.
Oh, I was going to say, this is Shane Stegmiller at Hannah News Service. How much consideration was given into filing a federal lawsuit or even with the Supreme Court on the voting rights stuff? Or is that still yet to come?
The federal courts do not have jurisdiction over political gerrymandering cases. Those cases, the Supreme Court ruled a few years ago, belong uniquely in state courts. So there's no opportunity to make this challenge in federal court.
Not even on the voting rights stuff, though?
Under the Voting Rights Act, there could be. That would be a claim of racial discrimination. This is a claim of partisan gerrymandering.
And just to add to what Freda said, as she said in her remarks, the Ohio Constitution explicitly calls for a fair map drawing process in Section 6 of Article 11.
Andrew, I think I might have cut you off when you tried to ask your question. Okay. Well, Andrew's question.
Yeah, I was going to say, this is Jessie Palmer with the Inquiring Gannett. I can ask both questions. Andrew says, what is the timetable likely to be for this lawsuit? And then I have another one that I can ask next.
This is going to be an extremely expedited lawsuit. It needs to be. We need a decision by mid-January, because February 2nd is the date in which candidates will have to file their petitions. They'll have to know what the district boundaries are in order to qualify for the primary election, which in the state.
Thanks. And my question is, how much does this challenge rely on Section 6? Did you challenge splits, population, other portions of the constitutional amendment?
The map that was enacted is a blatant violation of the very heart of the constitutional provision that guides redistricting. It violates the concept of fairness. It gerrymanders. And that's what our lawsuit addresses. We are not challenging anything technical about the map in terms of the little split violations and compliance with, how municipalities need to be divided. This is a pure Section 6 lawsuit. The map is a pure Section 6 violation.
Freda, Julie Carsmith at the AP. So in a guest column, Senator Huffman was suggesting that representational fairness is being used, I guess, unfairly, and that it's essentially an effort to gerrymander on behalf of Democrats rather than on behalf of Republicans, if I'm reading his guest column correctly. Can you sort of address the allegation that this is just special interests trying to use representational fairness to the benefit of a single party?
Certainly, the numbers tell the story. That Ohio is a little bit more than half Republican in terms of its voting behavior, and yet the Republicans are taking for themselves roughly 2/3 of the seats. So, of course, it's the party that is being deprived of seats that is asking for more. So yes, it would improve the Democrats' representation in the General Assembly if they won, but that would be to achieve fairness, not to achieve an unfair advantage. It would be to undo an unfair advantage that was obtained because people drawing the map do the map to favor themselves.
Julie, I'll just jump in here as the lead plaintiff, just to remind everyone that first, the League of Women Voters is fiercely nonpartisan. We do not endorse candidates or parties. I myself am held to very similar standards as news reporters in terms of what political activity I can do so that we can be beyond reproach. You know, we've been fighting partisan gerrymandering here in Ohio when both Republicans and Democrats have done it. And nationally, our organization has participated in litigation against maps that favored Democrats and maps that favored Republicans. Why? Because the problem is that gerrymandering pollutes our political process and therefore really distorts our ability to have fair representation and our ability to hold lawmakers accountable to the needs and will of the people.
And if I could just add one more thing, ditto on Jen with the ACLU and our nonpartisan position. I myself have worked on cases involving, for example, Maryland and a Democratic gerrymandered map. So Democrats do also gerrymander maps, and the ACLU is there wherever and whenever it is done. But all to the Huffman point, what Huffman and other members, Republican members of the commission have said is just blatantly ridiculous on its face when under Section 8 of the Ohio Constitution, they had to state how they were adhering to representational fairness. And Huffman put out a letter that said, well, we've won 81% of the contest, so we get 81% of the seats. If you take a state like California, that would mean you get 100% of the seats. And that is clearly not what Section 6 of the Constitution means. It means you should look at the vote share, meaning how many people are voting for each candidate. So if Biden gets 45% of the votes, that's the way you measure vote share. You don't say, well, Donald Trump won, so he gets 100% of the seats. That's not how you measure vote share. And that's one of the reasons that we've brought this lawsuit, because on its face, they were not complying with Section 6.
Thank you. That helps.
Okay, next we're going to take a question from Kathy Ann Kowalski, and then we'll get to Shane and Andrew Tobias after her.
Kathy Kowalski for Energy News Network and other publications. It's been mentioned that gerrymandering does not provide government that the people want. So I'm wondering if anyone can point to things that have happened in the Ohio legislature or particular laws that you might say are particularly bad that you would expect we would not have seen in Ohio, but for the gerrymandering that's been going on.
I can give a few examples. Some of the very extreme and very many abortion restrictions in Ohio are way beyond what a state in which the majority of the populace believes there should be reproductive justice would want. Our legislature is extremely polarized and anti-abortion rights. Similarly, people complain that the gun laws in Ohio, gun regulations, would be much more effective if the legislature weren't gerrymandered in such a way that these bills are constantly defeated. Some of the COVID restrictions, the inability of the government to help contain and manage public health has been restricted by the imbalance in the legislature. Those are some examples.
Thanks, Greta. Our next question is from Shane. He said, would a decision have to come earlier than January because of residency requirements for General Assembly candidates?
So under our calculation, a decision would need to happen in January because the map would go back to the commission to actually draw it in line with Section 6 of the Constitution, but by the filing deadline for candidates is in February, with the primary actually happening in May. So candidates just need to know by February what the districts are so that they can run.
I guess my question was, though, isn't there a residency requirement for people running for the General Assembly? They have to live in the district at least a year before the election. So wouldn't that move up the timeline earlier when a decision needs to be made? I know it's something Huffman has made an argument before as well, because he wanted to shorten that with the constitutional amendment earlier this year.
So from our analysis, the residency requirement is not a part of the calculation for when a decision needs to be made, and that the sole calculation is when candidates have to file by.
Okay, the next question is a follow-up from Andrew Tobias with Cleveland.com. He said, what do the attorneys make of the argument that Republicans could award themselves as much as 81% of the districts, and whether this type of argument has ever been used successfully in elections litigation? I know you briefly touched upon that, Elora.
I think Elora said that perfectly. It's not a winner take all. And just because Republicans have won elections, that means they get all the seats, or whatever elections they win, they get that number of seats. The language is very clear. To read it, the statewide proportion of districts whose voters, based on statewide, state, and federal partisan general election results during the last 10 years, favor each political party, shall correspond closely to the statewide preferences of the voters of Ohio.
Okay, thank you. We have a question from Brad Brooks with Reuters. He said, what are your national concerns on gerrymandering? And can anyone address ties between this gerrymandering and the baseless election fraud claims pushed by the Trump and taken up by the GOP nationwide?
So I'll take that one. I think we're going to be concerned and paying a close attention anywhere where the process is partisan. I think we've seen in Ohio the way in which a technically bipartisan process can be manipulated. So we're going to be paying attention to that everywhere. As far as the links between voter suppression and what Ohio is doing now, what you do see is Ohio is another state where there have been a couple of voter suppression bills introduced. And again, as Fred has said, that is a reflection of the polarized, gerrymandered nature of Ohio's legislature. And you can say that's similar in other places.
Thank you, Elora. Do we have any other questions?
Hi, Dustin Ensinger here with Gongwer News Service. I was wondering, does the lawsuit, does it call on the Supreme Court to draw its own maps? It seems to read that way in the prayer for relief.
No, under the Article 11 of the Ohio Constitution, the relief for a violation is for the Supreme Court to order the commission to draw a new map.
Hi, this is Jessie Balmert. I had another question. The language in the Ohio Constitution says shall attempt to do the things in Section 6. I guess how much harder is it to prove that they didn't attempt it versus if it was just shall do these things?
So the way in which we read shall attempt is it's telling you to read all of the sections of the Constitution together, meaning that you are attempting to get representational fairness while at the same time doing other things such as the split violations and other technical aspects. So to the extent that changing the numbers would require a technical violation, the Constitution does not tell you to do that. It's telling you to look at all of these things in concert. And one of the things that we've pled and seen is that there were alternative maps that would have better met Section 6 and met the other constitutional provisions.
In addition, the statement that Elora referred to, that the majority members of the commission read aloud their report as to their reasoning behind the map that they drew, states what their attempt was. It states the metrics that they were achieving, that they had achieved. And it was some blend of this 81% notion that of the seats that they thought they should have, with the 55% that they recognize represents the number of actual Republican, percentage of actual Republican voters. So they manifested their, very clearly what they did attempt to do.
I think we could also just point to the process to know that they couldn't possibly have attempted to uphold the Constitution and create maps that really serve voters when the process was marked by procrastination, refusal to hear from experts about legal interpretations or best practices for map making, and definitely putting party politics before the rights and needs of Ohio voters. When we see that process, we know that a bad process makes bad, unconstitutional maps.
We have another question in the chat that says, since the US Supreme Court has taken a hands-off approach on gerrymandering, how does that impact the Ohio State Court and what we're challenging?
So when the Ohio Supreme Court, when the US Supreme Court decided to take a hands-off approach, Justice Roberts explicitly said in his opinion that it was the providence of state courts and state constitutions. So we are doing exactly what the Supreme Court told us to do. And we've seen other states do this successfully in North Carolina, in Pennsylvania. So there is precedent for state courts to take on this issue.
And our state constitution expressly vests the state Supreme Court with jurisdiction and authority to handle partisan gerrymandering. There's a section of this Article 11 that says that these cases go to the state Supreme Court.
So I just want to say to all those out there who had their clipboards out to force the Republicans and Democrats to put this initiative on the ballot and then to get voters to pass it by 72%. Here's the thing, this reform has not failed yet because part of the guardrail is actually this backstop of going to the Ohio Supreme Court. Part of the reason why the League of Women Voters, along with many allies like Common Cause and A. Philip Randolph, were really excited about this reform is it because it gave voters the ability to address this issue before the Ohio Supreme Court if map makers put their own short-sighted interests first rather than creating a map that serves and fairly represents voters.
Along those lines, there's an interesting thing. There's a lot of rights that the Ohio Constitution provides to the people of this state. And many of them, yeah, the Constitution gives you the right, but you don't necessarily get to sue over it. This Article 11, actually doesn't just provide this right to the people of the state to live in a state that's not gerrymandered. It also provides that you can take any infringement of this right to the Supreme Court where it will be adjudicated. That's unusual and special.